Now that we've been through the arguments for Catholic Charities, it's time for arguments from Wisconsin Labor and Industry Review Commission, or more accurately, how the Wisconsin Supreme Court decided this case. Arguments are presented by Colin T. Roth.
Mr. Chief Justice, may it please the Court. This religious accommodation solves a particular problem posed by the unemployment insurance system. When determining benefit eligibility, the state must often resolve disputes over whether an employee was discharged for misconduct. If so, no benefits. Now consider churches and their affiliates whose employees express and inculcate religious doctrine through worship, proselytization, and religious education. For those employers, misconduct disputes could often force the state to decide whether employees complied with religious doctrine.
As I've already pointed out, the reason for the exemption is to disentangle government from questions of religious doctrine.
So Wisconsin gives those kinds of employers a wide berth by prophylactically exempting them. But because exemption means employees lose state unemployment insurance coverage altogether, exemption is limited to the employers most likely to draw the state into doctrinal disputes.
So the main concern of the state of Wisconsin, the compelling government interest in denying the exemption to Catholic Charities, is their employees won't be eligible for state unemployment insurance.
So Wisconsin's search for worship, proselytization, and religious education, much like the ministerial exception, thus does not decide what is religious in the abstract, nor does it discriminate among denominations. Instead, these activities are what reasonably limit the exemption to the employers most likely to pose entanglement problems.
In their attempt to keep the state out of doctrinal disputes, the state of Wisconsin places itself in the middle of a doctrinal dispute. Specifically, is the only religious purpose someone is exempt for limited to worship, proselytization, and religious education? In effect, the state of Wisconsin limits religious purpose to those activities regularly associated with the conduct of a minister.
Petitioner's motive-only test has no such limits. It would leave potentially over 1 million employees nationwide without unemployment coverage, like nurses and janitors at religiously affiliated hospitals, even though the state could virtually always determine their benefit eligibility without confronting religious doctrine.
Mr. Roth is incorrect. Petitioner's test would only leave this theoretical 1 million employees without state-provided unemployment coverage. Catholic Charities actually has its own unemployment insurance, which covers these employees. The state of Wisconsin also seems to ignore the fact that employment is a voluntary act. If someone perceives working for a religiously motivated organization above participating in a compulsory unemployment insurance program, isn't that their choice? Especially when you consider all of the other non-tangible benefits a religious person may gain from working for such an employer.
And petitioners' view that the First Amendment requires a motive-only test would radically expand similar exemptions like 501c3, Title VII, Section 702, and property tax exemptions, all of which examine what organizations do, not simply their motives for acting. Petitioner's theory ultimately leads to an all-or-nothing rule: exempt all religious groups or none. Such a rule could incentivize legislatures to cut back on religious accommodations altogether. I welcome your questions.
Petitioner's theory ultimately leads to an all-or-nothing rule: exempt all religious groups or none. Isn't that the point? Should the state of Wisconsin discriminate for one religious group and against another? Isn't that a violation of the 14th Amendment? No state shall deny to any person within its jurisdiction the equal protection of the laws? Well, the arguments before the court have focused on the First Amendment, erroneously, I believe. The real problem is the 14th Amendment's Equal Protection Clause. The state of Wisconsin is applying the phrase religious purpose differently based on how an organization exercises their religion. Chief Justice Roberts asked Mr. Roth a question that I think points to the problem.
What is the simplest thing that the Catholic Charities would have to do to qualify for the religious exemption in Wisconsin? Should they have one sign in the dining hall saying this meal provided by Catholic Charities? If you want to find out about the church, here's a brochure.
No, Your Honor. I think what we're looking for is precisely what this court looks for in adjudicating the ministerial exception. We're looking for activities that express and inculcate religious doctrine, worship, proselytization, religious education. And it's precisely because it's those activities that create the entangling problem with the state.
Except the state's view of their entanglement problem is so narrow and myopic, they cannot see beyond their desire to have as many workers as possible in their unemployment insurance system.
The core of the state Supreme Court's decision was a motive alone is not enough to qualify for this exemption. Catholic Charities here relied entirely on their motive. We think that affirming that core of the decision suffices to deny them.
The question before the court is, was the state Supreme Court wrong when they found that Catholic Charities was not religious enough for the exemption on their motive alone? Put another way, does your religious purpose end at worship, conversion, and education? Justice Kavanaugh asked Mr. Roth why sincerity of one's belief or why they engage in these activities shouldn't be considered.
Well, sincerity, so I took two hypotheticals given to the other side as examples of the edge cases that maybe we don't want to be exempting here. One was the hospital and one was the vegan restaurant. I think in both those cases, you're not going to weed those out on sincerity grounds. There's testimony in the record here. This is record 99 of the lower court record. The Archbishop of Milwaukee testified that he oversees multiple Catholic hospitals in the Milwaukee area. And so that's clear. They're clearly operated for a religious motive. We would never dispute the sincerity of that religious motive. They're going to be out. Seventh-day Adventists, similarly, maybe it's commercial activity they're engaging in.
And they're going to be out. Why? Just explain that.
They're going to be out because when they run their vegan restaurants, what they're saying.
I think you're on the hospital one.
Oh, the hospital? Well, they're out because what the hospital is saying is if it's supervised by the bishop, which is all this statute requires, the bishop will say the reason we run these hospitals is to serve. I mean, Christ healed the sick, and we're doing the same. And so how can you tell us that that's not a religious purpose? They'll be out, even though 99.9% of what goes on at that hospital is health care.
I think Mr. Ross blew up his argument right here. He states that because a bishop oversees Catholic hospitals, they must have a religious purpose. What happened to worship, conversion, and education? In other words, because they are overseen by a bishop, they have religious motives. What about another hospital that has the exact same motives, but their denomination doesn't have a bishop?